Winding up of a company is a process whereby a company's life is put to an end and its net assets, if any, are distributed among the members of the company. So there are two ways in which a company may be wound up, and we can refer this in section 432 subsection 1 of the Companies Act 2016, which are voluntary winding up and compulsory winding up. Creditors may bring a petition to wind up a company under section 464 subsection 1, in which it listed down persons who may bring a petition to wind up a company. A creditor's voluntary winding up is the winding up of the company by a special resolution of the shareholders of the company under the scrutiny of the company's creditors. So this occurs when the company is insolvent. If the directors of the company are unable to provide a declaration of solvency, then the company may proceed with the creditor's winding up.
Firstly, a creditor may petition to wind up its debtor on the ground that the debtor is unable to pay its debt. The statement unable to pay its debt has to be taken in the commercial sense of being not able to meet the current demands of the company, may be otherwise solvent. According to section 4661 of Companies Act 2016, there are three circumstances when a company will be deemed to be unable to pay its debt. Firstly, the creditor is owed a sum exceeding the amount prescribed by the minister. Currently, the amount is Rm 10,000. The creditor or his agent has served a notice of demand on the company at its registered office, requiring the company to pay within 21 days after the service of the demand. If the company failed to pay the sum or did not secure or compound it to the satisfaction of the creditor may, by virtue of section 4662 of Companies Act 2016, file the petition to wind up the company within 6 months from the expiry date of the notice of demand. The limit applies even where the creditor has not obtained judgment, but the court may not order winding up if there is a genuine dispute on the debts. Secondly, the creditor has obtained judgment against the company. Though the creditor has executed the judgment, the execution did not net sufficient proceeds to satisfy the judgment sum. Thirdly, the court is satisfied that the company is unable to pay its debt after taking into account the company's contingent and prospective liabilities. In other words, the company's liabilities are more than its assets. For example, in the case of Sri Hartamas Developments Sdn Bhd and MBF Finance Berhad, the applicant company was ordered by the High Court to be wound up as it was unable to pay its debt. An application for stay of winding up order was also refused by the High Court, and the official receiver was appointed as the applicant's provision liquidator. The applicant appealed against the winding up order, and pending the disposal of the appeal, it applied to the Supreme Court for stay of the winding up order.
The respondent raised a preliminary objection that the applicant was not entitled to apply for stay. The respondent further argued that the application was not properly before the court because the affidavit in support of the application was affirmed merely by the applicant's solicitors. The held for this case stated that an application for stay of a winding up order only can be made by the liquidator, creditor, or contributory of the company. However, where a debt is bona fide disputed by the company and the court is satisfied with the company's defense, a winding up order will not be made. In the case of K. Apparao and Saka Chemicals P. Limited 1995, the Andhra Pradesh High Court held that where a company has a prima facie sustainable defense or a bona fide dispute of its obligations to discharge the alleged debts or liabilities, the court may not entertain proceedings for the winding up, much less order winding up. Besides, in the case of Syarikat Muhammad Nur Yusuf Sdn Bhd and Polybina Engineering Enterprise Sdn Bhd 2016, it was also held that a winding up petition is not a legitimate means of seeking to enforce payment of a debt which is disputed. The general rule is that no winding up order will be made on a debt which is bona fide disputed. Thus, a creditor may bring a petition to wind up its debtor on the ground that the debtor is unable to pay its debt. However, where a debt is bona fide disputed by the company and the court is satisfied with the company's defense, a winding up order will not be made. Therefore, a petition for winding up on the ground of inability to pay debts must contain all the relevant information about the debt. The petition must disclose the assets of the company and whether they are sufficient to meet the liabilities, including unforeseen and expected liabilities. Where a winding up petition has been presented against a company and one or more of the statutory grounds for a winding up order has been established, the court has a discretion whether to order the company to be wound up.
Assalamualaikum. My name is Nurul Rabiatun Azura. I will continue with the second reason for creditors to bring a petition to wind up the company. The second reason is no declaration of solvency. So we will start with a brief introduction. Based on Section 444 of Companies Act 2016, creditors can file a petition to wind up the company when there is no declaration of solvency by the sole directors or majority of directors. The requirements of the directors' declaration of solvency are prescribed in Section 443 of Companies Act 2016. Next, we will go to the requirements needed in the solvency statement. First, by virtue of Section 443 subsection 2, the declaration must be made before the notice calling for the members meeting to decide on the winding up of the company is given to its members. The declaration must be made by the sole directors or the majority directors of the company which stated under Section 443 subsection 1. The written declaration shall contain the affairs of the company which was highlighted under Section 443 subsection 1 paragraph A, which an opinion has been formed that the company will be able to pay its debt in full within 12 months after the commencement of the company's winding up, which is under Section 443 subsection 1B, and a statement on the assets, liabilities and the estimated expenses of winding up of the company by virtue of Section 443 subsection 3. By virtue of Section 443 subsection 4 paragraph C, the declaration must be lodged with the ROC before the notice calling the members meeting is sent out. Last one, Section 443 subsection 4 paragraph B stated that the declaration is made within 5 weeks before the resolution for voluntary winding up. Next, we will go to the application. We use the case of LRH Services Limited in liquidation versus True and others. So, for the facts of the case, the liquidator of LRH Services Limited brought an action against 3 former directors of the company in connection with a reorganization of the group of companies which they had carried out and which involved a reduction of share capital. It was held that the solvency statement made by the directors was invalidly made on the basis that the opinion of solvency had not been properly formed by one director. It was further held that in making this assumption, the directors failed to make any inquiry or give any consideration for the company's actual liabilities as is required by the legislation. The result was that the solvency statement was found to be invalid. Thus, when there is an invalid, there is no declaration of solvency. Next, in relation with the question, here we can see that the declaration of solvency under the 2016 Act are required to state that the declaration have made a full inquiry into the affairs of the company, informing the opinion that the company will be able to discharge its debt and other liabilities. When a company failed to give a valid declaration of solvency, which they did not comply with one of the requirements needed in the declaration of solvency, the declaration was invalid. Thus, there was no declaration as to no compliance of the requirement needed. Hence, creditors can file a petition for winding up to the company instead of the members voluntarily winding up. For the issue of no declaration of solvency, we can conclude that declaration of solvency is necessary for winding up. Therefore, if the directors of the company are unable to provide a declaration of solvency, the company can proceed with the creditors winding up. Thank you.
On this reason for a creditor to bring a petition for winding up is by conversion of members voluntarily winding up to creditors voluntarily winding up. So, in this situation, creditors voluntarily winding up will have the effect on Section 449 of Companies Act 2016, and it will proceed as such if the liquidator subsequently discovers that the company is actually insolvent contrary to what the directors has declared, then the liquidator should summon a meeting with the creditors. Once the meeting of creditors is held under Section 448, the liquidator must convert members' voluntary winding up into a creditor's winding up. Although it is not expressly provided under the provision of the Companies Act, it is submitted that the meeting under Section 449 also refers to the meeting of creditors where the company directors did not make a solvency declaration. So this is further explained within the subdivision 5 of Section 449, where if a declaration is made in reference to Section 443 subsection 5 of the same Act, the liability of a director who makes a declaration of solvency without a ground of opinion that is reasonable to be for the company to pay debts in full within 12 months period, the declaration would be amount for to be false and inaccurate. Thus, the solvency declaration declared hasn't been made at all. So, based on few of cases, under this reason I have mentioned earlier, so referring to the case of Sri Raja Mohan Manucha Lashman, it was held that where the declaration of solvency is not made in accordance with the law, so the resolution for winding up and all subsequent proceeding will be null and void. So another case I have referred to is Ray Caramelli and Barnett, which in this case the court held that the company has to convene a meeting of a creditors to take place immediately. So the creditors at the meeting have the right to nominate a liquidator, and if their nominee is different from the nominated by the shareholders, thus the creditors' nomination prevails, subject to the power of interference of the court. Thus, the creditors are given a controlling voice in the winding up of an insolvent. So that's all for the reason for the creditors to bring a petition for winding up.
In conclusion, the difference between creditors' voluntary winding up and members' voluntary winding up is that the latter is only an option if the company is solvent and there is director's declaration of solvency. Solvency is the company's ability to pay its debts as and when they fall due. So when a company fails to pay its debts, then the company is insolvent. Another key difference is that in members' voluntary winding up, it does not involve creditors because the company is still solvent and it still has the ability to pay its creditors. The process of the creditors' voluntary winding up is much more complex if we want to compare it with members' voluntary winding up, because usually the creditor will have to conduct a thorough investigation and analysis of the company's assets when they want to pay the creditors in that situation.